Hi, everyone, and welcome to episode 20th of Study With Me. European Union Law, this podcast helps you get ready for your university exams and gain a deeper understanding of the subject.
Today, we are undertaking a critical deep dive.
Our mission is to track the fascinating, and I mean absolutely critical legal history of how fundamental rights were integrated into EU law.
And this really isn't a dry legal history. It's a high-stakes story.
It is. It's defined by initial blindness, major constitutional conflict, and a pretty dramatic legal shift engineered by the European Court of Justice, the ECJ.
That shift, that internal legal revolution, is what makes this deep dive so important for understanding modern EU.
Exactly.
Grasping this evolution is crucial for grasping the legitimacy, the coherence, and, the ongoing supremacy of EU law over national systems.
So we're essentially tracking the narrative from an initial legal silence.
All the way to a comprehensive written codification. Let's start at the very beginning, the Treaty of Rome.
Right. So when the European Economic Community, the EEC, was founded, the Treaty of Rome was famously silent on fundamental rights protection.
It was. And for those of you preparing for exams, this silence is the absolute foundation of the whole story.
So why? Why did the founders just, intentionally leave out human rights?
Well, because the initial purpose of the EEC was purely utilitarian. It was economic.
Just about building a common market.
It was all about market integration. The treaty affirmed fundamental freedoms, like the free movement of goods, capital, people, but those were instrumental freedoms. They were there to serve economic goals.
Right. Not fundamental rights in the way we think of them, protecting citizens from the state.
That whole idea seemed completely alien to the initial market-driven project.
You have to remember the context, right?
You do. At the time, fundamental rights were already robustly protected at the national level. You had the German Basic Law, the Italian Constitution.
So the assumption was just, we're dealing with coal and trade, not civil liberties. The national constitutions will handle that.
It was an implicit and I'd say arguably naive assumption, but it proved flawed very, very quickly.
Because even purely economic rules, they're going to affect people's rights.
Inevitably. Rules on property, on how you can run a business, they immediately touch on fundamental rights, things like property rights or the right to pursue an economic activity. This sets the stage for an immediate confrontation.
It certainly did. And that confrontation started right away, with the ECJ drawing an incredibly hard line in the early 1960s.
They essentially established what you could call an irrelevance doctrine.
Declaring that national fundamental rights were just not something the community courts should concern themselves with.
Exactly. Two early cases really define this rigid stance. They show you just how closed the ECJ felt its system was. First, in 1959, we have the Stork case.
Okay, what happened there?
The ECJ stated very clearly that the high authority in the court were only required to apply community law. They explicitly ruled they were not competent to examine a complaint that a community act infringed principles of German constitutional law.
Wow. That must have been a shock to German lawyers. You're basically telling them your highest constitutional guarantees don't apply here.
It was a profound constitutional claim. And if that wasn't clear enough, the 1960 Knoll case just reinforced it.
Doubling down.
Absolutely. Here, the court stated plainly that it was not for them to ensure respect for rules of internal law, even constitutional rules. The message was clear. EU law operates in its own box, and your national constitutional rights, well, they stop at the border of our competence.
Okay, let's unpack this, because this is where the story pivots into pure legal drama.
It really is.
The ECJ's position, this irrelevance doctrine, it created a ticking time bomb.
It did, because shortly after those cases where they said EU institutions weren't bound by national rights, the ECJ dropped two constitutional bombshells that established the supremacy of the whole community legal order.
And you're talking about, of course, the revolutionary principles of direct effect in Van Gent and Loos in 1963.
And then the massive one, the primacy of EU law in Costa v. NEL in 1964.
Exactly. And this created this awkward, I think ultimately untenable paradox.
A huge one. On one hand, the ECJ is demanding the supremacy of EU law over all national law.
Including national constitutions. The very documents that protect fundamental rights.
Precisely.
Yeah.
And on the other hand, the court is affirming that EU institutions themselves were not bound by any equivalent fundamental rights standards.
So they're saying you must follow our law even if it contradicts your constitutional rights, but when we make that law, we don't have to respect human rights. I mean, to a national constitutional judge, that sounds like an invitation to tyranny.
It was a crisis, and it immediately triggered what we call the counter-limit doctrine from national courts, especially in Italy and Germany.
This is Solange.
The famous Solange judgment in Germany in 1974, and also the Italian Constitutional Court in Frontini in 1973.
And what did they say?
They essentially claimed the power to scrutinize community acts. They argued that if an EU law violated the fundamental principles of their national constitutional orders, well, the national court had a right to step in.
Meaning they could just make the EU act inapplicable in Germany or Italy.
That's exactly what they were claiming. They said they had the last word when fundamental rights were at stake.
So the stakes could not have been higher.
Not at all. If national courts had the last word, it would have completely undermined the uniformity of the entire EU legal system. It would have led to its disintegration. The ECJ had backed itself into a corner.
And that's why, to cope with this, they performed one of their most decisive changes in position, what we should really call a 180-degree reversal.
It was a huge legal maneuver that happened incredibly quickly in the late 1960s.
What were the key shift?
The key shift was recognizing that fundamental rights were not external, irrelevant concepts. They were, and remain, part of the general legal principles of EU law.
They internalized them.
By internalizing them, the ECJ transformed the entire conflict.
So what's the first sign of this change?
The first real sign comes in the 1969 Stauder case. Here, the ECJ, while interpreting a provision, stated that it contained nothing capable of prejudicing the fundamental human rights enshrined in the general principles of community law and protected by the court.
That's a huge change in language.
It's a massive signal, and it paved the way for the seminal 1970 Internationale Handelsgesellschaft case. This is the ruling that really laid out the reasoning that resolved the crisis.
So for exam purposes, this is the one to focus on.
Absolutely. The court first reiterates its hard line. The validity of community measures can only be judged in light of community law. National constitutions can't affect their validity.
But then comes the brilliant maneuver.
Yes, the solution. The balancing act between EU law and fundamental rights is now attracted or pulled within the EU legal order itself.
So it's no longer a constitutional fight between, say, the German Constitution and an EU regulation.
No, it becomes a balance between two EU norms, the EU regulation versus the internal general principles of EU law.
So they basically took the fight out of the national arena and pulled it inside the EU house.
Precisely. Which means they, the ECJ, control the rules of the fight. They remain the ultimate constitutional authority. It fully preserved the principle of primacy.
They saved their legal order by adopting the very rights they had spent a decade denying.
It was a masterful move.
So what practical consequences does this theory actually have?
It immediately gave the legal system a crucial standard for legitimacy. First, fundamental rights instantly became essential interpretive criteria for all EU law.
And the most powerful consequence.
They become the ultimate touchstone, the yardstick, for assessing the legitimacy of everything the EU institutions do. An act of secondary law that violates these fundamental principles can be annulled or declared invalid by the ECJ.
That's a massive power. And this standard, it extends beyond the institutions themselves.
It does. Since these rights are now part of primary EU law, member states must comply with them when they are implementing union law.
That's a key point. Only when they're acting within the sphere of EU law.
Right. It wasn't a blank check. Now, the ECJ didn't just invent these principles overnight. Where did they get them from?
Good question.
The court explicitly said they were inspired by two main sources. First, the constitutional traditions common to the member states.
So they looked at what all the member states already had in common.
Exactly. That common heritage provided the substance. Second, they looked at international treaties, especially the European Convention on Human Rights, the ECHR.
Which all the member states were already parties to anyway.
So it made perfect sense. Now, this case law approach was a brilliant way to manage the crisis, but eventually, the political desire for clarity demanded something more formal.
Demanded codification.
Right. And that's what we got, gradually. It moved from non-binding declarations up to the Maastricht Treaty, where Article 6 of the TEU formalized the whole thing.
But the real game changer in terms of codification is, of course, the Charter of Fundamental Rights.
The CFR-EU, yeah. It now has the same legal value as the treaties themselves.
The highest form of law. But for students, we need to be crystal clear on its scope. Who is bound by the Charter and when?
This is Article 51 of the Charter, and the key case is Åkerberg-Fransen. The Charter applies to EU institutions, always, but it applies to member states only when they are implementing union law.
So the scope of the Charter is the same as the scope of EU law itself.
Exactly. It doesn't expand the EU's powers. It just dictates how existing powers must be used.
And since rights are rarely absolute, Article 52 governs their limitation.
Correct. And any limitation has to meet very strict criteria. It must be provided for by law, it has to respect the essence of the right, you can't destroy the core of it, and it must comply with proportionality.
Necessary, adequate, not excessive.
The whole package.
Okay, finally, let's just revisit the ECHR relationship. Even though the ECJ used it as a source, the EU itself is still not a party to it.
No, it's not. Accession is actually foreseen in the treaties, but the S1E20 agreement has been rejected twice by the ECJ.
Why? What's the problem?
The primary concern is the potential risk to the autonomy and unique structure of EU law. If the EU joined the ECHR, the court in Strasbourg would become the external, ultimate arbiter for rights within the EU sphere.
And the ECJ doesn't want an external court having the last word on EU law.
That's the heart of it. The ECJ essentially refused to share power.
But despite that, the ECHR standard is still deeply embedded.
Absolutely. Thanks to what's called the principle of equivalent protection, Article 52 of the Charter requires that any right corresponding to an ECHR right must be interpreted to offer at least the same level of protection.
At least.
Yes. The EU can always choose to raise the level of protection higher, which again maintains the ECJ's supremacy.
That really brings us full circle. We started with an economic treaty that actively ignored human rights.
And through a period of intense legal crisis, the ECJ performed a complete 180-degree reversal.
They created a system where fundamental rights are now essential internal principles, ensuring EU law's validity and supremacy.
And the strategic use of those unwritten general principles was just a masterful piece of legal necessity. It preserved the legal order by deflecting the challenge from national courts, and it forced everyone to comply with a high human rights standard when acting within the EU sphere. It's a classic example of problem-solving under extreme pressure.
As you prepare for your exams, keep this narrative arc in mind, especially that central period of constitutional tension. The ultimate question for your study is this. If the ECJ had not performed this reversal, if they had stood firm on the irrelevance doctrine, what would the current relationship between the German Basic Law from Solange I and the Treaty on European Union look like today? And would a unified European legal system even have been sustainable?
A great question for further reflection on the power dynamics within the EU.
Thanks for diving deep with us today. We'll see you next time.